everyone, and welcome to another episode of Church Coffee, Christianity, Conservatism, and Culture. Today I'm joined by Walter Olson. He is a senior fellow at the Cato Institute, Robert A. Levy's Center for Constitutional Studies. He writes on law, public policy, and regulation, and today we're here to talk about recent developments in the Equal Rights Amendment. So, Mr. Olson, thank you for coming on.
Thank you for having me on.
So let's first and foremost give us a definition of the Equal Rights Amendment and a short history, perhaps going up to 1982.
Well, the Equal Rights Amendment, which has been discussed over much of our lifetimes or all of our lifetimes, depending on how young we are, would say that equality of rights in the United States shall not be abridged on account of sex. It parallels, in its advocates' mind, what we already do with race. The post-Civil War amendments prohibited not only the federal government, but also the states from discriminating on the basis of race. And when the Equal Rights Amendment came along, and it was a very different time. Back when the ERA was proposed, the Supreme Court had already become very active in trying to bring in a new and much wider approach to rights. These were things that had been ignored, but they were timeless. They were moral obligations. There was very little complexity to them. It was our job as Americans to modernize the country by just recognizing them and running. And, even at the time, there were some complications, and we'll get to those. But it was very popular, and the ERA in particular. Now, the process of changing the Constitution as provided by the framers is a pretty cumbersome one. And looking back, we realize some constitutional amendments were adopted quite quickly, but in fact, it requires not only for Congress to give it the send-off, that's assuming that you haven't done it through some sort of constitutional convention or something, but then it requires 3/4 of the states to ratify. And among the states that quickly ratified were places like Texas. And Texas was not some, huge old, feminist state at the time. But these were different times, and people saw the pluses. They saw that in many ways the law had held women back in ways that we would now never have countenanced. And that goes to things like jobs that they were permitted to do. A lot of, something like working late at night was often forbidden to women. And so you move on to questions like how is property handled in a marriage. The modern consensus is, of course, women can own their own property. The old idea of coverture that they become one legal person had already become outdated even by then, and so people just felt, okay, let's correct the statute books quickly, pass one thing, instructing the judges to get rid of all of it. They were already getting rid of a lot of the things piecemeal and individual decisions. And we'll get back again to the fact that much of the ERA, maybe even nearly all of it, happened through court reinterpretation without passing the amendment. But this was very much happening at the time. But there was some opposition, and that was coming from recognizably a part of the American conservative movement, which had become strong, and which, even though much of the conservative movement agreed that we wanted to equalize the law's handling of men and women for the most part and over most issues, there was a figure named Phyllis Schlafly from St. Louis, who had been a successful conservative author and something of a national figure because of her writing and her speaking. And she led a campaign to argue against and discourage ratification of the ERA. And she got her audience. People began to listen as she warned that in specific areas, you might find that you didn't want the law to completely require equal treatment of men and women. She even, I believe, mentioned bathrooms at the time, an issue that I can guarantee absolutely no one foresaw coming in any way, but probably more weighty as far as something that people would listen and nod on was the military draft. Uh, the country had long, and we were much closer to a point where the military draft had actually been used in the Vietnam War and earlier. And the country had always drafted young men. It had never drafted young women. It never even required young women to register under the selective service. And there was, as you know, perhaps there still is a consensus that this made sense. That if you were a libertarian, of course, you didn't like the draft at all for anyone. But if there was going to be one, people thought, look, this is men and women of the ways in which they are different. War has always treated them differently. And the idea of women in combat was extremely controversial at best. And even those who believed there was some role for it typically didn't believe that you had to ignore
Yeah,
gender. And yeah, go ahead.
I typically think that even in my generation is actually a pretty strong argument against it. I know plenty of women who do not want the selective service. I remember getting my selective service card at 18 and kind of having a cold blood moment of just like,
Oh,
oh,
yeah.
I could get drafted. Now, then within 20 seconds, you realize that's almost not going to happen. It's political suicide post-Vietnam, but I do see also a sense from the lowercase l liberals of, well, a woman could vote to a female senator or female representative could vote to initiate the draft again, but that's only
Yeah.
going to affect 49% of the population. Not even 49%, it would probably affect 20 or maybe even 18%. A quick fact check here. The population of 18 to 25-year-old males, which are needed for the selective service, is 6.6% of the United States. But I do see both that I see the logic of both why that was scary and also maybe why that should also be implemented. But that is,
Yeah. Well, so that argument got some traction, and it was interesting because some advocates of the ERA would actually, and not necessarily the most passionate and devoted ones, but some advocates of the ERA would say, "Oh well, you know, that won't actually happen. The courts will straighten it out. Even if the language is there, they will still recognize that there are some issues that are important enough that you can't literally apply the law. Look at other parts of the Constitution that they don't literally apply. So so you can see how the doubts got in, and yet most states ratified, and and we were still, as I say, far, far away from questions of whether or not distinctions between the genders for bathroom use and locker room use and so forth would sports participation would have any problem, because the overwhelming majority, even of people who were urging ratification, believed that they would not have any effect on any of that. The it gets enacted in a large number of states, approaching but not reaching the three-quarters that are necessary to declare it ratified and declare it part of the Constitution. And then it slows down, and and then the um, uh, the question of whether or not it is going to expire comes up, because in the original bill, there was a time limit written right into the language. Now, uh, some ERA advocates later on said, oh, well, it was just put in the preamble, so it doesn't have any legal effect. Now, I am not an expert on preambles, but I will say that there are people in jail because of what is in the preamble of laws. There are people who have won or lost large amounts of money in litigation because of what was in the preamble of laws. And by and large, courts very often do say, it was enacted as part of a law. It sheds light on what the expectation was of enacting the rest of the law, even as we cite sometimes the preamble of the U.S. Constitution or other things. No, you don't get to disregard a time limit. So Congress extended it. Now, you can have a big argument. I don't think I'm going to have one here about whether extending a deadline for states that believed that they were facing a certain deadline actually undercuts the legitimacy of their ratification. I think it kind of does, because I think that if you sign a contract and it says, this explodes unless you sign by next Tuesday, the other side, so to speak, and it's not clear who is the other side here, but someone other than you should not be able to extend the Tuesday to Saturday and say, well, we've all decided, all of us who are signing this contract, that it'll later. But wait a minute, when I signed, there was an exploding deadline of Tuesday. Doesn't this mean that I get released from it because I considered that to be a crucial condition? Well, they never asked that. They just said, surely we can extend. We've almost got a consensus. Let's just go ahead. Well, so even the extended one finally lapsed. It really did lapse. There were, after a point, no more extensions. And so even the argument that they could extend the deadline without asking all the signers lost its force. They just couldn't do it. But so it then began to be argued that, the deadline doesn't really count. It was just in the preamble. And how about trying to get some states? And this was, by this point, quite a few years had passed before they began getting a push for a few more ratifications. States like Virginia that had not ratified the first time, but were politics or whatever had changed, and it might be that they were friendly enough to enact them. Um, the argument was, let's get a few more states to ratify. We'll be up at the magic number, and we can declare it to be part of the Constitution. Now, aside from the time,
Yeah, just as a pedestrian observer, I also see that kind of logic of, ooh, should we extend this or not? But I kind of, I don't know, just as as a lay observer, excuse me, as a lay observer, I do see the kind of like, oh, you're so close, let's give it a little bit more time and then we'll call it quits. That's like not great, and I can see how that could actually fail under technicality, but even as a conservative myself, I kind of see that, okay, we'll give it that overtime limit just to see if you can convince a few more people.
yeah, and the practical political background was that it still had strong majority popular support as far as people's opinion. And when you have that, often there is a wish to give a little more leeway, and people see things as technicalities and so forth. Now, as time went on, of course, opponents became somewhat more confident and won over some additional opinion. The whole thing seemed for a while to recede into the past, and if you believe, and this gets us into deep waters, but necessary waters. If you believe that the ratification of an amendment to the Constitution is kind of like a contract between the different states that are doing it and the people as a whole who are going to live with whatever gets ratified, then if it's kind of like a contract, then shouldn't there be a quote meeting of the minds, unquote? And that's this magical phrase. But it's one that you do hear often when the law construes contracts and contracts that may have been completed, back before the lifetime of the people who are now bound by it. So whose minds met? Was there a quote contemporaneous meeting of the minds? That is to say, not only did both sides of the contract want it, but did they want it at the same time so that the minds met, rather than just both, incidentally occupied the same spot, but 20 years different times. And that's what gets us into not only the question of whether some ratifications could be so late that it's not fair to the ones that ratified earlier because it was a different generation. It was, but also it gets us directly to the question of, well, okay, can states rescind? Can states make clear that the consensus that they may have had way back then, in their mom's day, if not grandmother's, no longer applies, and that their current sentiment is against the thing? Rescission makes more and more sense if you believe that the process is legitimate, even if it's drawn out over a long period, because it gets you closer to the idea of meeting of the minds. It doesn't get you perfectly close, because obviously you could have a state that had turned against it, but doesn't have enough political momentum in that position to rescind. But nonetheless, it at least provides some simulation of an even playing field for the yes side and the no side. So yes, in fact, there were some rescissions that happened, and here's where, uh, in my view, the advocates just got so ambitious that they began to lose a lot of people who had started out as sympathetic, which is they said, no, rescissions will never be valid. We're never going to count them, but we're always going to count new ratifications, no matter how late they happen. And yes, for some of us, that was the point at which we said, hey, wait a minute. You're
Well,
just
weren't there states, I'm not sure if it had already been ratified and then states tried to
right.
unratify, but
These are
weren't there some um, Reconstruction amendments that were that states did try to rescind the ratifications?
well,
I think
right.
I think
And
mostly
so,
the 13th Amendment, but if I'm vaguely remembering it
yeah,
correctly, it had
the
already become a verified amendment and they were trying to
right. The rule is
de-ratify it after it had already been 100% been a part of the Constitution.
that, yeah, there is no doubt, I think, that if a state tries to rescind after a thing has already been enacted into the Constitution, uh, it's void. It's like trying to take back any other legal act that has reached completion and gone into effect.
Yeah. So,
Uh,
but during this period, I mean, it's what both sides are arguing. Wouldn't that be still a technically unresolved legal area?
yeah,
I would personally think that before it's been, stamped and approved and made part of the Constitution, states should have the
and
ability to rescind. But I do understand in my non-law understanding that that actually is a problem that hasn't been solved or at least litigated on.
right. Well, no, that's perfectly fair. And of course, a lot of stuff went on at the time of the post-Civil War amendments that uh, may or may not pass for current accepted practice, because the country was still carrying out kind of the Civil War type, war by other means. But yeah, it is legally unresolved, and I don't believe the Supreme Court has ever had to consider whether or not um, uh, rescission before adoption of an amendment is legally valid. Uh, I'll just say that for a lot of people, and this was one of the things that former or that the late Justice Ruth Bader Ginsburg mentioned in her comments, which we'll get to. Uh, the um, the fact that you had a number of states that had tried to rescind um, was uh, something well worth considering in deciding how uh, uh, fair the overall process had been toward opponents. The to to deny rescissions might be a lot easier to swallow if you also enforce the time limit, or if you enforce something reflecting contemporaneity, to use the $5 word. The simultaneousness of states supporting it, and so uh, these controversies uh, meant that even though they got a few more states to ratify, it was always considered, um, uh, touch and go legally whether or not their arguments would stand up. I believe when Virginia ratified, not that many years ago, its advocates were saying, "Well, this does it. Uh, there is no one to say no. We have now officially enacted it." But it's always more complicated than that legally. In fact, a constitution gets onto the
And
book.
Virginia was the 38th, so
Well,
there were two other states that ratified it in that resurrection period.
you remember the count better than me, and that sounds right to me. That sounds consistent with my memory. And the but of course, uh, as I mentioned, it's more complicated, and although some things are self-enacting, you that people just begin obeying the new law or celebrating the new holiday or whatever the thing is without even asking Washington, D.C. The fact is that with constitutional amendments, there is a process by which the archivist of the United States, an official who most of us never need to think about in policy terms, although we may learn about their existence when we visit, the great monuments in Washington and see documents and things. And then we learned that the archivist does some important stuff. But the archivist turns out to do stuff that has policy significance when she, in this case, or he, inscribes, that's not the word they use, but publishes an amendment as part of the Constitution. And that wasn't happening. Um, uh, and there was so a campaign went forward, a campaign on several different fronts. Well, if we can't do it just by having Virginia and a couple of other states announce that it's happened, we will get the president to call the archivist, who is a presidential appointee, and say, do this. Or maybe we can get Congress to announce that it's been done, of dubious significance whether Congress has any role in coming back that way. But neither of these work. There wasn't a majority in Congress willing to overlook the objections and the scruples, and the Biden administration, and in particular its archivist of the U.S., Colleen Shogan, and her deputy, um, made clear a few years ago that they didn't want to do it, and then more recently, that what has brought us to the present day is that the advocates of declaring the ERA enacted, seeing that Biden had become a lame duck and looking for ways to possibly get over the finish line, since it seemed less likely that Congress or the White House would be cooperative from January on, said he should just order the archivist to do it. And this is where it looks as if that was successfully resisted, because the archivist and her deputy put out a statement saying, essentially, we've looked at this, we've considered the arguments, we've considered the opinion of the U.S. Department of Justice, which I believe under both Republican and Democratic recent administrations has said that it cannot be declared enacted. And this is sufficiently persuasive to us that absent a change of legal authority, we can't and we won't. And
Well,
the
and under Biden, Biden fell back on, I think in 2022 there was a federal judge ruling on that the timeline stayed, like you after 82, I think it was, the amendments, not the amendment, but the hopeful amendment that the ERA is dead, that the timeline holds, that you would have to start over. So not only did the federal bench, but also Ruth Bader Ginsburg
well,
offering some opinion, right? And
yeah,
then President Biden, to his credit, stuck by what uh,
yeah,
people who know the law better than he did, probably at least issuing in their opinion. So he had come out several times saying, "I'm just going to follow the law."
well, yeah, and to back up a bit, I think advocates would say that the federal courts did not rule as conclusively on that. It's kind of teasing, and because the courts have come close to ruling on several of the composite issues. Um, they did uh, give the advocates a little bit of hope because they made one ruling which suggested that they weren't going to be looking for a contemporaneous meeting of the minds. But there's another case, and it actually goes way back, suggesting that um, the court believes that Congress can constitutionally prescribe time limits, as it has done for many amendments in modern times. The court uh, gave the nod to time limits being real and having legal effect there. So the even though I believe the Supreme Court has not squarely addressed it for a ruling, uh, the the cases that are on the books suggest that the court would not accept the ERA as ratified. And let me expand on that a little bit because people say, "Oh, well, it's a conservative court." No wonder. I don't think it's just that it's a conservative court, but yeah, if you want to start there, the fact is that playing these sorts of games, and I'm getting a little bit editorial, but I think some games were played on this, um, doesn't appeal to many of the originalists and textualists who dominate the current court. It is perhaps something that believers in a so-called living constitution, would be more okay with, but that's not this current court. And when I say that it's not just a matter of today's, call them what you will, conservatives, originalists, textualists. Uh, I'm finally going to call that witness that I mentioned a couple of minutes ago, the late Justice Ruth Bader Ginsburg, who is, let's face it, the most uh, admired and respected liberal justice of the last generation. And she was asked about this at a speech at Georgetown University's School of Law, and she said, my opinion is that they should go back and start from the beginning again, start the process over. And she cited, and these were fairly brief remarks, but she cited um, the expiration date having been part of it. She cited, and she did cite the rescissions, which she, I think, weighed as part of the fairness element here. And she said. She had never changed. She had been a lifelong advocate of the ERA, and I think she would have been right there cheering had the process begun again of trying to get it passed again. But she said, "You just should stop trying to pretend that you can get this over the line." And there, I don't think that she was just speaking in some sort of uh, legal realist sense of the current court would never accept it. So even though I would, it sounded like she was speaking for herself too. And that's why I uh, warn people who advocate this particular method, don't be so sure you're going to get the liberal justices. It is true that on certain symbolic issues, they tend to line up and all vote for the position that is seen as progressive. But even when a deeply heartfelt issue is at stake, you'd be surprised how quickly they can find standing issues or procedural issues to say, we don't actually have to rule what our heart's content might have been. The liberal justices have been doing that too, some to skip getting to the decision point and just saying some procedural or standing thing was not ratified. So they,
Let's say for a moment it does, on some level, in this current version, end up in front of the Supreme Court. Do you think, this is clearly you're asking your own opinion, which all three would vote against having this be ratified? Which do you think would waiver? Which do you think would maybe do it?
I,
Is there one
I
that
think they, I think that the six right and center right justices would say that it was not validly ratified. I think the interesting opportunity, the likeliest opportunity for a swing is Elena Kagan, who has been the most wedded to um, the principles of legality makes it sound mean to the other two, but she is the one who has been most willing to accept, let me call mechanical. That's a less sympathetic way of describing the idea that you can't bend the rules even when you've got a really sympathetic case. Now, Ketanji Brown Jackson is an interesting case because she has shown some sympathy for some uh, uh, originalist and textualist principles, often with a twist that allows her to come off in a completely different position. Uh, in my view, Justice Sotomayor has been the one who, but even she, will occasionally. I don't think this is an issue where she would. I think she would read everything in the light of, what is the reading that could sustain this, and if you're willing to do enough readings in a row, you know, in a hopeful state of let's hope that it could sustain it, then yes, some people, do arrive at the view that it's been sustained. That the great majority of the Democratic state attorneys general, for example, have declared that they think that it's been ratified. A what is it? Maybe 12 or 18 judges or governors rather. Um, it is a position, the American Bar Association, and I won't get into why I don't rate the American Bar Association's opinion very highly. You'll just have to take that as my subjective opinion. They've waded into political issues too often to have kept their original reputation as sticklers for the law, if they ever did have that. But with the attorneys general, presumably they answer to an electorate that could, lift their eyebrow at a obviously frivolous legal interpretation, and so they're going to trust that it's not read as obviously frivolous by the people who have to reelect them in their states. Could we hold up for just a moment here while I blow my nose? We
Yeah, I feel pretty similar about the Supreme Court. It'd be 6 against. Kagan would definitely be the one if there was one to vote with the majority, it'd be Kagan. And yeah, I also Jackson's been surprising. Her and Gorsuch have teamed up several times in dissent, which is very, you would think, unusual, but Gorsuch kind of filling the role of Scalia as the heterodox, very pro criminal justice um, supporter. And Scalia was very much a defendant of criminal rights, which a lot of conservatives never understood. But him being a textualist and certainly an anti-tyranny person, and with Gorsuch kind of filling somewhat that chair, so to speak.
they're both
That actually kind of jives, especially with him and Ketanji Brown Jackson coming up on
Gorsuch.
dissents every now and then.
Gorsuch and Jackson are both skeptical of the government and its motivations and its uh, offered rationalizations, and that comes across, with Gorsuch, of course, it comes across in the regulatory area too, where he's very skeptical of the reasons the government offers for wanting to do some vast scheme of regulation. But in the case of Jackson, she's got a willingness to look at things from a different angle. It's that often leads her to, as you say, these slightly anti-establishment positions. If you believe the prosecutors and the police represent the establishment, as they surely do. Um, it's uh, so yeah, I don't want to um, presume too much about individual justices because all 9 of them are in the end their own um, thinkers, and surprises do happen. And the I can't tell you how many times Justice Clarence Thomas has baffled people who thought that they could predict his opinions because he um, uh, has his own view and he sticks to it no matter what. So that on issues like punitive damages in class actions, where the Republican justices are ordinarily expected to support tort reform. There is Clarence Thomas, having thought through the relevant sections of and dormant commerce clause, having thought through the relevant sections of the Constitution, he decides he doesn't agree with the way conservatives have interpreted them, and off he is, as a lone dissenter, or sometimes with liberals. Anyway, that was a sidetrack, but I just have to say, they're all at some level, completely capable of following the intellectual logic where it leads them, even if it's not where we thought it would.
So we don't have prescience here. We cannot see the future, but if you had some guesses on where either activists might want to still challenge the archivist, or what maybe future rulings might hold if there are lawsuits coming up maybe against the archivist, what do you think is next for the ERA?
Well, the archivist has already been sued once. Back when Virginia ratified, Virginia and two other states, Illinois and one of the others, sued the archivist, saying, by law, you must publish the amendment. And they lost. Now, they lost on a standing type issue, I believe. Nonetheless, I can't believe that they want to try again and just, so far as I can tell, lose again, because not enough has changed to change the standing issue that they failed on last time. So with all of that, I think that there could be extreme long shots efforts to raise the issue, which I don't think would even get to the Supreme Court, or raise the issue at a lower court, saying that you can't enforce such and such a law because the ERA has been ratified. That's not going to fly. I would say that this is an issue that we are probably going to set aside in our mental cabinet for a few years, assuming that Biden doesn't surprise everyone and in fact declare it ratified, or send an order down, which I don't think he will. I think where this is likeliest to come back is if the national political mood changes. Both houses of Congress could go Democratic within whatever, 4 years, pick your number. The presidency could be held, for all we know, by Alexandria Ocasio-Cortez. And so when those sorts of things change, we will come back and look at this again. And I hope we remember some of the lessons we've learned thus far.
Mr. Olson, thank you so much for joining Church Coffee. We'll see everyone next week.
That's great. Thank you.
Our album art was done by my wife, and our theme music was composed by TJ Stokes.